Good morning and welcome to another week of United Way for Southeastern Michigan's What's the Word Wednesday, where we share important resources and have vibrant discussions about topics that matter to you most. My name is Audrey Walker, and today we are here to discuss a topic that often gets overlooked, but is so important to many of us, elder law. As you've hopefully heard by now, United Way's third annual 21-day equity challenge kicked off last Friday, and we couldn't be more excited and eager to embark on 21 days of new equity-focused content with thousands of our friends here in Metro Detroit. In coordination with this year's Equity Challenge, all of our What's the Word Wednesday town halls in May and June will feature topics, organizations, and speakers that relate directly to diversity, equity, and many other important topics highlighted throughout the Equity Challenge. We hope that you'll continue to join us over the next few weeks as we take a deeper dive into some truly critical and timely topics. Today's town hall will touch on how we can all better support ourselves and the older adults in our lives with support from great organizations like Lakeshore Legal Aid. Before we dive in, I've got a few reminders here for our audience. We'll take questions from the audience, so please put any questions you have in the chat box on Zoom or into the comment section if you're watching on Facebook. Closed captions are enabled in Zoom and Facebook Live. To turn them on, please click on the Show Captions button at the bottom of your screen. Aging with dignity and respect is so important to us all, and yet it is a topic that's often overlooked. Each of us are either aging ourselves, will enter late adulthood one day, or love someone and maybe caring for someone who is aging. Older adults are pillars in our communities, bringing us wisdom, love, and should be honored and cared for as they age. However, as of 2021, 39% of older Americans are living one paycheck away from financial despair, and over 12% are living in poverty. Ensuring older adults have legal rights and advocacy is just one important component of caring for people that are aging. I'd like to introduce you to our guest today, Tracy Dominique Boyd from Lakeshore Legal Aid. Lakeshore Legal Aid provides free direct legal representation in Southeastern Michigan and the Thumb area, and also provides client intake advice and brief legal services throughout Michigan via an attorney-staffed telephone hotline. Tracy serves as Lakeshore Legal Aid's Director of Staff Development. And prior to joining Lakeshore in 2012, Tracy served as Assistant Friend of Court for Wayne County Circuit Court in Detroit. She is a past president of the National Lawyers Guild Detroit and Michigan chapters and has served on the boards of directors for the Michigan Family Support Council, First Step Project on Domestic and Sexual Violence, Wayne State Law School Alumni Association, City of Inkster Downtown Development Association, and the Detroit Bar Foundation. Tracy received her bachelor's degree from Kalamazoo College and received her JD from Wayne State University Law School. Welcome and thank you for being here with us today, Tracy.
Thank you so much, Audrey. I really appreciate the introduction, and I appreciate the opportunity to speak to all of you about the importance of planning for your future and doing that end-of-life planning piece to ensure that as we age, you are treated equitably and with respect, and that you have made the decisions that will govern your course or your path toward the end of your life. Next slide, please. So when we talk about doing that pre-planning piece and putting documents in place that will help govern the end of your life, we always have to look first to make sure that the individual doing the planning has the legal capacity for decision making. What does that mean? So capacity is a spectrum and often a moving target. A lot of folks have a preconceived notion that as we age, the natural aging process necessarily limits or diminishes our capacity to make our own decisions knowingly, voluntarily, and make decisions that are in our own best interest. But that's simply not the case. Please keep in mind that the capacity to make your own decisions or lack thereof is not age-based, it's not gender-based, and it's always on a continuum. For example, if you lose consciousness due to an accident or a trauma, you have lost your capacity for decision making. The lack of capacity can be temporary or it can be long-term and progressive. Whenever we're talking to an individual, whether it be an older adult or a younger adult, we need to make sure at all times that we are testing to ensure that they have the ability to make their own decisions and make educated decisions on their own behalf. And so preparing end of life and preparing for end of life is one of those situations. Next slide, please. There are many different tools that you can prepare or have prepared on your behalf in order to plan for the end of your life. Now, we're all going to die someday, right? I mean, that's inevitable. We don't want to think about it. But as a lawyer, I'm always talking about death and dying, and that makes sometimes people a little uncomfortable. So I would encourage all of you to embrace that, embrace the inevitable. And it's always better to plan ahead, especially now while you're able to do so and while you have that capacity to make your own decisions. So these are some of the tools that Lakeshore Legal Aid staff attorneys can assist you to prepare in order to make sure that you have properly planned for the end of your life and or for any diminished capacity or transition that you might have as you move toward the end of your life on this earth. So one of those documents is a durable power of attorney for financial transactions. So what does that mean? Let's break that down a little bit. The word durable means that the document will survive any transition you make into a phase of your life where you no longer have the legal capacity to make your own decisions. Power of attorney means that you are giving some or all of your decision-making power to another adult person, another third party, and you're giving them permission to exercise that decision-making power on your behalf when you reach a stage of your life or a moment in your life when you're no longer able to do so on your own. And financial transactions is a very broad term. When you are creating a power of attorney, you're actually creating a contract between yourself, because you're the one with all the decision-making power on your behalf, and one or more trusted other adults, and you're giving them specific written instructions that define the scope of the power they have and define a triggering event to enable them to exercise that decision-making power on your behalf when you're no longer able to do so on your own. You can create a durable power of attorney contract for basically anything, any decision-making power. In fact, we do it all the time as adults, right? For example, if you and your partner are going to purchase a parcel of real estate, buy a house, sometimes one of you is not able to appear at the closing. That's okay. One of you can exercise a power of attorney, giving the opposite partner the legal authority to sign all of that paperwork, not only on their own behalf, but also on your behalf. Usually when you create that power of attorney, it's going to have a very finite beginning and end to it, right? Because there's a very specific single task that you're giving the opposite person the authority to create, enact, execute on your behalf. But durable powers of attorney, we usually want to last long term. Another very common form of durable power of attorney that I propose you should consider as part of your end of life planning is the durable power of attorney for healthcare. Again, that is a contract where you, while you have the ability to make your own medical treatment decisions, are putting into writing instructions for another adult person or persons that you trust to let your treating medical professionals know what your decisions are for medical and healthcare treatment if you're not able to communicate those on your own behalf. It is important to understand that you should be as specific as possible when giving those instructions, because at the moment in time that that document has to be relied upon, you won't be able to give any clarification or explain what you might have meant by those instructions. Durable powers of attorney for healthcare can have limits. They can have expiration dates or sunset dates, or they can remain durable and valid through the remainder of the adult person's lifetime. As long as you still have that legal capacity for decision making, you can always change or modify any of these documents. But once you reach a phase in your life or a moment in your life where you no longer have that capability, that is when the documents must be relied upon in their entirety. A third form of end-of-life planning document that Lakeshore Legal Aid staff can help you prepare is the advance directive. Most people call these living wills. So if you've heard somebody refer to a living will or the need to create a living will, in the lawyer's mind, in our own special language, we refer to that document as an advance directive. So an advance directive charts the course for your end-of-life medical treatment as you make the transition out of the earthly world. And so it can be as narrow or as broad as your current intent and desire is. Usually in an advance directive, you are going to be somewhere along a continuum of how you want your end-of-life medical treatment to look. Some folks prefer to be a do not resuscitate, no heroic measures, no life support, and that's fine, but you need to put that in writing so that your family and friends understand and respect your decision when the time comes to communicate that to your treating medical professionals. You could be at the other end of the spectrum. You could decide that you want your body to be kept alive as long as possible by any means necessary until you are ready to make that transition into death. And that's fine too. But again, put that in writing because that is your directive. Those are your instructions. And in so doing, in making that living will or that advance directive, you're putting in place instructions that must be followed by anyone who's given notice of them. I always recommend that folks make their advance directive part of their medical records with all of their treating current medical professionals, because you never know what hospital you'll end up in, and you'll never know which medical professional will be the first to transmit your medical history records to that treating emergency room. A lot of folks fall somewhere in the middle on that spectrum between do not resuscitate and keep me alive as long as possible. And that's okay too. What's most important to understand is that you're clear in your instructions to your loved ones, because when the time comes to give those instructions to the treating medical professional, it necessarily will be a highly emotional time for the folks that love you. They may want to make selfish decisions that may conflict with what your expressed desires are for end-of-life medical treatment. So it's so important to preserve that autonomy of body and autonomy of self to now, while you're able to make those decisions and express those decisions in writing, put these pre-planning documents in place. The appointment of beneficiaries is a tool that is used on accounts such as investments, stocks, certificates of deposit, bank accounts, and other structured forms of holding on to assets, whether they're tangible or intangible. The appointment of beneficiaries gives written instructions on who will gain an ownership interest in that property once you die. And so now we've reached that bright line of death that I warned you about early in the presentation. Powers of attorney and advance directives or living wills. All of those instructional documents are in place to govern your care while you're alive. That's important because the moment that you die, you have no more power to give. Your light's been extinguished. So those powers of attorneys die with you. And the advance directive or the living will dies with you. So any other person that you gave decision-making authority to exercise during your lifetime while you were no longer capable of communicating your wishes, they no longer can exercise your power to make decisions because your light's been extinguished. That power no longer exists. So now let's talk about all of the documents you should still put in place now while you're living to have written instructions for the folks that survive you so they know what to do next. So the beneficiaries are the folks that would gain ownership of those tangible or intangible assets that you have appointed prior to your death on those accounts or on those holdings or investments. A trust is another form of pre-planning that a lot of folks consider doing. When you create a trust, in essence, it's like creating a mini corporation where you're the president and the CEO because it's all your stuff, right? Except in order for the trust to work and to protect your assets after death, you have to actually give up ownership of your stuff and put it into the ownership of that trust, that fake mini corporation that you've just created. So now the trust owns everything. So for example, if you own real estate, if you own a home, you need to execute a deed from you as the homeowner to your trust, because now your trust needs to own that home in order to avoid needing to open a probate estate to change ownership interest once you die. Similar but different with all other aspects of your tangible property or your intangible assets, money. Anything that you want to be able to pass outside of the realm of the probate court system, you would need to put into the name of the trust. You would need the trust to hold on to or own that property prior to the moment of your death. As part of the construction of the trust, you must appoint trustees and successor trustees. Those are the folks who will be the successor CEOs and run that trust and manage that property that's in the trust once you pass on. And that's important because the trust takes the place of a standard inheritance type structure. Trusts normally are not indicated for individuals who do not have a lot of stuff that they need to manage after their death. Trusts are normally not indicated if there's no real estate and if it's a very low asset existence that you're living. And that's okay. Trusts are not required to avoid probate. Another form of pre-planning that folks usually consider or know about is the will. So under Michigan law, when you create a will, you can have an attorney help you do that, type it up so that it's very legible, everyone can read it, or you can hand write it yourself, sign it and date it in your own handwriting, and that will is just as valid and enforceable as if an attorney had drawn it up for you. So there are some caveats. If you have another person type up your will, or if you type it yourself, if it's not in your own handwriting, then it needs to be properly executed. So what does that mean? That means that you and two independent witnesses have to gather together for a type of ceremony, sort of. You sign that will in front of those witnesses, and the witnesses also must sign it because they need to attest to the fact that you were of sound mind and body when you executed that document. You have to have two witnesses that know you and that can attest that you had the legal capacity to make that decision when you executed or signed that document. That's important. That helps protect you from exploitation and from potential fraud or theft following your death, because you won't be able to control your stuff at that point, right? So when a will is constructed, if there is any real estate involved and it's included in the will, your loved ones will still need to open a probate court estate to probate that will in order to transfer ownership of a real estate interest. Why? Because when you sell real estate at that transaction, the seller has to be present as well as the buyer for the closing to proceed, right? Some of you may already be familiar with that concept. Well, after you die, as the property owner, as the seller, you can't show up for the closing. And so the probate judge stands in the place, and the probate judge approves the sale or transfer of any real estate through that probate court case. The downside is if you die with any debt, even if it's unsecured debt, those debtors get paid first from any proceeds of the estate. You may not want that to happen. You may want your loved ones to be able to inherit or to take over ownership interest of everything that you own at the time that you pass on from this world. And that's okay. That's important to most people. And so the other way that you can transfer real estate, or that you can pre-plan for the transfer of real estate, is by executing a separate deed called a transfer upon death deed, or a lot of folks refer to that as a ladybird deed. So the myth behind the title Ladybird Deed is that Lady Bird Johnson, President Johnson's wife, was a big proponent of keeping the government out of your personal business. And so that is allegedly how that term of art was created to describe this type of real estate transfer. When a transfer upon when a transfer upon death deed is properly executed and recorded, it ensures that real estate ownership can transfer smoothly without the need for opening a probate court lawsuit in order to have a judge approve the transfer and the probate court, take their statutory cut of the proceeds, and the creditors get to dip in as well. We don't want that, right? We want our stuff to go to our loved ones. So if you have an ownership interest in real estate, please consider this estate planning option as part of the entire package of end-of-life planning that you may choose to do while you have the legal capacity to make those decisions. So the way a transfer upon death deed works is you, as the owner of the real estate, you maintain 100% free and clear full ownership of that real estate, of that home. But with the document, you've created what's called an enhanced life estate for yourself. You have created a future interest in one or more other adult people that doesn't take effect until the moment you die. But at the moment you make that transition out of this life, automatically ownership shifts to those folks that you created the future interest in, or the springing interest in your real estate. So that's important. No one has to do anything except register a certified copy of your death certificate with the Register of Deeds into the chain of title, so that they know that the triggering event of your death has occurred. Then clear title automatically passes in the public record to whomever you created that future interest in your transfer upon death deed. No probate court needed. If it's a family member, no property transfer tax needed. It's exempt under Michigan law. So that's so important, particularly for folks that have a family home that's been in the family for generations. We don't want the chance that creditors might destroy that and might try and take that away from your loved ones.
I hate to interrupt. This is such good information. I just wanted to make sure if we had some time for questions, but I know you were just getting to your final point here, so I'll let you finish with that and then we can go to some questions, okay?
Sure, not a problem. Thank you for keeping me on task.
Yeah.
It's a lot of information, so I'm sure there'll be a lot of questions. I put joint ownership on the slide because I just want to talk about the fact that joint ownership is tricky and it opens the door for potential financial exploitation of you as an adult, especially as you become more vulnerable, either with health infirmaries or with declining mental health capacities. Joint ownership means that more than one person owns the thing. So a lot of folks think that during their lifetime, if they own a home, in order to prepare for death, it's a good idea to execute a quit claim deed to add one or more adult children onto the deed or the ownership path of that home. I highly recommend that you do not do that for a number of reasons. Number one, now you don't own your home. You plus however many adult children you added now own the home. If you need to refinance the home, if you need to sell the home, if you need to do a reverse mortgage to pull equity or a home equity loan to pull equity out of that home in order to meet your daily needs, you're no longer able to do that. All of the co-owners have to agree to it and they all get a share because everybody owns the house, not just you at that point. The other reason it's a bad idea is every real-time transfer of interest in real estate takes off that Headley Amendment property tax cap. So if you've owned your home for a long time, the Headley Amendment, that property tax cap has protected you and has said that even if your home value has shot through the roof, the tax assessor can only bump your property taxes up to 3% each tax cycle. That's to try and protect your ownership interest from property tax foreclosure. But once you transfer interest, that cap comes off. And so if you do that quit claim deed, even if it's a pocket deed, even if you do the quit claim deed and put it away and your loved ones don't register it until after you die, guess what? The property tax assessment office is going to reassess back to the date you executed that deed, and your loved ones are going to get hit with tens of thousands of dollars in unpaid back property taxes, which may force them to sell or give up their ownership interest in that home that you intended to protect for them following your death.
Mhm.
Next slide, please. I want to touch briefly upon the concepts of adult guardianship and adult conservatorship, because if you do not do the pre-planning pieces, if you do not put those durable powers of attorney into place that set forth your instructions and appoint at least one trusted adult to make decisions for you when you're no longer capable of controlling your own life safely, then that guarantees that another adult person, once you no longer have capacity to safely make your own decisions, will need to go to the probate court and ask a judge to give them permission to make decisions for you. If none of your loved ones survive you, or if you don't have any trusted individuals that you trust enough to appoint as a power of attorney for you before you reach a phase in your life where you lack capacity, then it's very likely that a professional guardian or professional conservator will be put in place to manage your affairs when you're no longer capable of doing that on your own.
All right, Tracy,
So,
I just want to jump in here real quick because
sure.
I want to be mindful of the time because we do have just a couple of questions before we wrap up. And you have shared so much amazing information with us today. And I love the way that you are talking about this information too, because it's very easy to understand, some of the different things. So one of the questions I have for you is can you and I know we really only have like a minute here,
I'm so
but
sorry.
I was just curious. No. So much good information that you have for us. What are there particular common struggles that you see when dealing with the clients every day? And then if you can just kind of touch on real quick, maybe what is one thing that everyone can do today that would be helpful, for the future and all the different things that you've talked about today?
Sure, absolutely. So the most common struggle that individuals have is we don't want to die. And because we don't want to die, we don't want to talk about it because we think if we talk about it, then we've manifested it, right? Now it's real, except it's inevitable, at least at this point in modern history, right? We know that at some point we're going to die. We know that at some point we'll lose consciousness and not be able to control our destinies. So
Mhm.
that's why pre-planning is so important. It's hard. Talking about death is emotional. It's always hard. We got to do it. And so if there is one of the documents that I've talked about today in the laundry list of tools,
Mhm.
I would highly encourage folks to put in place an advance directive or a living will. Because if you have strong feelings about how you want your end of life medical treatment to look, put it in writing now. Because there is no guarantee that when the time comes to make those decisions, that your loved ones who are under the great weight of your impending death are going to make decisions that you would want to be made.
Mhm. All right. Well, thank you so much for joining us. I know we have this last slide here that has some contact information of how people can get in touch with Lakeshore Legal Aid for counsel and advocacy law line. So we have shared that number here and more information in the chat about Lakeshore Legal Aid and more legal resources. So we really appreciate all the information you were able to share with us today. Very important information for all of us, as you mentioned. And, thank you so much for joining us. So as we are closing, we just have a couple of updates for the audience here. As I mentioned earlier, we are currently experiencing our 21-day equity challenge. So we want to make sure we started last week. If you want to join us, you can still join us. You can sign up today at unitedwaysem.org/equity challenge. There's a lot of opportunities to connect with your neighbors about equity issues that matter. And definitely still time to sign up. The challenge is free, and we would encourage all of you watching today to join us for that. As a reminder for anyone who may be experiencing a need, our 211 helpline remains available 24 hours a day, 7 days a week. And this includes resources like food, utility assistance, and much more. We always maintain a running list of available services in the community and can connect you to the support that you need. So you can also look up resources in your area by using our 211 resource database at unitedwaysem.org/211. Our next town hall, our Equity Challenge Town Hall series continues next week on June 7th with a panel discussion with several LGBTQIA+ organizations in honor of Pride Month. So be sure to tune in for that town hall and more coming up this month and next month. To stay updated on any upcoming topics and watch replays of previous town halls, please visit unitedwaysem.org/virtual town halls. Thanks everyone for joining us today, and we'll see you soon. Stay safe and continue to live united.